Sir, the Insolvency and Bankruptcy Code, this bill, is a much needed change that was required in the country. And therefore, I rise to support
Nakvidi,
the bill.
Nakvidi, come.
So we have dated laws when it comes to bankruptcy and insolvency provisions. Going back to 1909, Presidency Towns Insolvency Act and 1920 Provincial Insolvency Acts. And only there are 3 provincial towns where the courts can deal with it, particularly when it comes to the issues relating to bankruptcy declaration as well as the recoveries. And that is confined to Chennai, Kolkata and Mumbai. And for the second law, the Provincial Insolvency Act, to the subordinate courts. I may mention here, sir, that the existing regime is considered to be inadequate, flawed and time-consuming, primarily because the dissuading factor for any investor, for any entrepreneur, is that to start an enterprise, there is always a fear of dealing with multiple laws, especially if one realizes that investment was a wrong choice or it has failed, the enterprise as such, then to deal with scattered laws for revival, to exit or for restructuring. So when I talk of a maze of laws, from the SICA Act, the Sikh Industrial Companies Act of 1985, Recovery of Debt Due to Banks and Financial Institutions, RDD BFI Act of 1993, then the SARFAESI Act, that is for Securitization and Reconstruction of Financial Assets and Enforcement of Security Interest Act 2002, and the Companies Act 1956 and the 2013, when this code was being discussed, and even in the select committee where it was referred to, it was very clear that the 2013 Companies Act is yet to be notified. Then, sir, these laws also provide for multiple forums, from BIFR, where a failed enterprise issue for reconstruction, for revival, for the payment of the dues to the creditors, to the workers,
I'll
or
request
the
for silence
interest
in
of
the
all the
House, please.
stakeholders. So if there is some order in the House,
Please,
I think
please.
the government members are non-serious about it.
I'll request you, please.
If you are going to have this, then you can adjourn the House.
No. And the ministers can't do this anyway.
So as I was referring to, there are multiple forums which exist today to address this issue when their enterprises fails, or the issue of recovery, workers' dues, creditors' dues, from BFIR to the Debt Recovery Tribunal, DRT, then the NCLT, which is yet to become fully functional, the high courts, and the appellate tribunals, and finally the Supreme Court of India. And there are also informal mechanisms for debt restructuring, and it's a big issue in the country today. That debt restructuring issue, because of the NPAs, which has climbed to 7 lakh crores, the defaulters, and also enterprises which fail, and the businesses where insolvency and bankruptcy proceedings must start. And these informal mechanisms are the Corporate Debt Restructuring Guidelines of 2012 CDRs, the Joint Lending Forum Guidelines, and the Strategic Debt Structuring Guidelines. Sir, what is important is to understand that when an enterprise fails and the proceedings have to start, the present regime does not do justice to the workers or to the creditors And when it comes to the first charge, in the existing regime, it would be the recovery of the tax or the government dues. And that is exactly what this present bill seeks to alter, the priority, through a waterfall mechanism where the workers' dues get the first priority. And yes, the creditors too are assured. What is important that when an enterprise or business is found to be unviable, then what should be the action to be taken? Recovery of the creditors' dues, all stakeholders. At the same time, not to condemn it to die a slow death, but to look at the possible revival by bringing in a new management, giving an opportunity to the existing one, and if not, then the last act is for the insolvency processes to start and to be concluded. So we know that this is the first step, but an important step, because after this, many laws will have to be amended, and it's 11 laws will have to be amended. Then only this process, which we are starting with this, will be completed. So it's going to be fairly exhaustive, but at the same time, what is equally important is that we are creating a mechanism through a comprehensive law which gives a legal protection to the creditor's rights and the debtor's needs for a facility to reorganize the enterprise or to obtain relief. It also provides for timely revival of viable businesses, the liquidation of the unviable ones, as I've said, the minimization of losses to all stakeholders, and saving the value of the failed businesses. There are many salient features which are commendable. That the entire process has to be time-bound in 90 days, and of course there is a period of extension which is given. It also makes a very clear distinction between legitimate failure and malfeasance, and a forum for consolidation. Now, forums for consolidation, as I referred to earlier about the multiple forums, here there will be only two forums now for the recovery. NCLT, that's the National Company Law Tribunal, and the Appellate Tribunal, and the Debt Recovery Tribunal, and the DRAT. So we're bringing in through this code insolvency professionals, which we have not in our country so far brought in at all. And we are separating the commercial from the judicial by bringing in this insolvency resolution professionals. And in addition to that, agencies which will be dealing with them. Therefore, I personally feel that the provisions of this bill, which also will help in collecting, collating, and authenticating and disseminating the information which is required for investors, for entrepreneurs, and for all stakeholders, is made available. The insolvency information utilities are established, which will help in collating, as I said, and disseminating the information which is much needed. There is also a clear provision for an early recognition of financial distress and a swift processing of the proceedings. Now, the trigger is also important, that who can start the process. But through this law, either a financial creditor or operational creditor or individual or corporate creditor can start the insolvency proceedings. And therefore, without going into more details, and once again pointing out and underscoring that 11 more laws will have to be brought before the the Parliament, before this House,
Okay, thank you.
including the Sarfesi Act and the DRT. This is a good beginning. And that's why my party has decided, always we have taken a progressive view when it comes to reforms. Now, allow me to put that on record because we are supporting it.
I'm not
now,
saying
don't look at the Times, my party's Times.
I'm not saying anything.
So we have always been in favor when it comes to something constructive, positive and progressive. And that's why, if you look at the journey of this country, from the first reforms and liberalization process in 1991 to where we are, it is because of their thought, the philosophy and the contribution. And I would also like to say here, for record, that it's important that when it comes to bringing about important changes, whether it is about this particular issue of insolvency and bankruptcy, or bringing about structural changes on taxation issues, or any other major policy which impacts the country, the states, to have a broad-based consensus. Unless and until we are able to build a bipartisan consensus, we cannot then take forward in a correct manner the measures that the country must take and the institutional mechanisms that should be put in place. Here, this is happening because together we have been able to build a bipartisan consensus, and with these words,
Thank you.
I commend this bill and support it.